This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.
Hi, and welcome to Smarter Lawcast with Hall and Wilcox. My name's Mark Dunphy, and I'm a partner in the Employment and Workplace Relations team at Hall and Wilcox. Today, I'm joined by my colleague Melinda Bell, who's a special counsel in our Employment and Workplace Relations team, and her and I have worked very closely together for many, many years. Today, we're going to be discussing the topic of underpayments. Underpayments is very topical at the moment in the employment and workplace relations space and has been now for a number of years. Underpayments claims have been getting an enormous amount of publicity. Today, Melinda and I will be mentioning many examples of where underpayments have been made. I want to stress that they're not ones that we have been involved with, but they've been ones that have been receiving a lot of publicity. For obvious reasons, we're not really at liberty to speak about the ones that we have been involved with or are currently involved with. So, Mel, it seems like everywhere you turn at the moment, underpayments, the issue of underpayments comes up. And there's been some really big names over the last 4 or 5 years with very, very substantial underpayments, whether it be Coles, Woolworths, etc. In your experience, how much of this is really going on?
Yeah, Mark, I think, everyone's seen the Coles and the Woolworths example, and it's easy to put that, aside and think, oh, that's in the hundreds of millions and they're the ones with the big problem. But what we're really seeing, I think, in our practice is that there is quite a lot of this actually going on. Yes, it's impacted some of the big names, but what we're seeing is that we're seeing all manner of employers across so many different industries impacted by underpayments in some way. From it might be, hundreds of thousands of dollars up into the millions. So it's certainly a growing issue, and it's something that's certainly taking up more and more of our practice.
And in your experience, Mel, are the payments deliberate or inadvertent? And it's a bit of a leading question because, in my experience, very few of them seem to be deliberate. It's more a result of the difficulty many employers have with following our very complex IR system of awards and enterprise agreements, and how difficult they can be to interpret and follow. I was wondering if you have a view with regard to that.
Yeah, I agree, Mark. I think, what we see is 99% of our clients and employers are getting themselves into trouble inadvertently. It's the complexity of the industrial relations system that's causing, or their awards and enterprise agreement system that's causing them issues. So we're seeing things like the incorrect application of entitlements under enterprise agreements. So something misinterpreted or entered into a payroll system incorrectly. And then that goes unchecked year on year, and when agreements are renegotiated, and then you see that issue, perpetuating in quite a significant underpayment, impacting potentially thousands of employees. So those sorts of things it's certainly contributed. The complexity, coverage clauses, and so forth can create big issues. But what we're also seeing is the impact of some real business continuity issues. So changes in IR and ER processes and systems and people. So it might be, business knowledge about how enterprise agreements have been interpreted, or how they've been applied. We have personnel changes or payroll system changes, and then things don't get caught, and we're seeing issues arise where that loss of business continuity and that corporate knowledge is then impacting where entitlements aren't being provided to employees correctly, and we ultimately have an underpayment claim arising.
Yeah, I think it's sort of ironic that they arise under the very instruments being awards and enterprise agreements that are created under the Fair Work legislation, where the Fair Work legislation itself indicates that its aims or the objects of it are to provide a straightforward, simple system of terms and conditions of employment for businesses of all size in Australia. But maybe that's a topic for us to go into another day. Why is it a significant issue for businesses, Mel? What are the sorts of issues that businesses need to manage, and the different stakeholders when there is an underpayments issue that comes up?
Yeah, I think, Mark, the easiest thing is obviously the employees don't receive the correct pay. So they don't receive their correct remuneration, the superannuation, and so forth. So that's, the huge impact on the employees and how it impacts them personally. But from an employer perspective, dealing with an underpayment claim or a remediation is it's a significant undertaking by all parts of the business. It's really labour intensive rectification process, particularly if you've got a widespread underpayment issue. It might be a little bit less so if you've just got one small issue, but in a widespread or systematic problem, it requires a lot of resourcing to actually to remediate and rectify these issues. So, from a business perspective, you're going to need your internal resources. So that's comprised usually of your HR, your in-house legal counsel, industrial relations team if you have one. You'll also involve your payroll team, because inevitably you're going to need to go through payroll records and time and attendance data, dealing with those sorts of things, and also the finance team dealing with, not only the rectification and remediation, but also, there's all the reporting and flow-on effects as well. So, from an audit perspective and disclosure requirements for large proprietary limited companies and also listed entities, you're going to need access to your board or, your ELT. And briefing them is a significant undertaking. Although I think boards are getting more and more sort of au fait with these issues, unfortunately, as they arise more and more frequently. And to rectify the time and cost of outsourcing as well, because you're most likely going to need external legal support to go through that, and also forensic accountants or data specialists to go through and manage that process. So that can be quite costly for a business, but it's not something that most businesses can handle internally just from a resourcing point of view.
I think another big issue that arises for employers, Mel, is with regard to publicity, and particularly where it's discretionary spending by consumers, it can be really damning. And as an example of those, some of the high-profile underpayments cases involving restaurants run by celebrity chefs over the last few years, the results or the publicity resulting from those overpayments has effectively resulted in the end of those businesses. So I think that's something that employers really need to be aware of as well. Let's have a chat about what happens with the process when an employer discovers that they do have an underpayment issue, and then I want you to tell us about what what sort of thinking goes on with an employer about when and how to involve the Fair Work Ombudsman, and why they need to involve the Fair Work Ombudsman, or why they need to give consideration to involving the Fair Work Ombudsman.
Sure, thanks, Mark. I think this is an issue that's so difficult for everyone to navigate, because unlike perhaps some of the more sophisticated regulators or other areas of law, we don't have a mandated reporting obligation. There's nothing in the Fair Work Act that says if you have X value of issue, then you need to go off and disclose to the Fair Work Ombudsman. But what we do have is the Fair Work Ombudsman compliance and enforcement policy. So that's what regulates the way they'll go about managing compliance and deciding whether or not to litigate or issue proceedings for penalties against an employer who's breached their obligations under the National Employment Standards or the Fair Work Act or industrial instruments. But what we've really seen, I think, from in the last sort of 4 years in particular, I would say, is a real shift in thinking around underpayments. And I think traditionally there was a view that even among the more conservative lawyers that there wasn't a need to necessarily disclose to the Fair Work Ombudsman if you had what we'd say was a minor or a low level underpayment. However, the Fair Work Ombudsman did very clearly change its litigation policy and sort of said that if there is an underpayment that extends sort of beyond a year, or it's a pattern of systemic sort of conduct, then they would expect you to disclose. And what we've seen as a result is this sort of tidal wave of disclosures. So, from the hundreds of thousands of dollars through the millions, as a result of that policy shift. So, and the reason that we're seeing that disclosure is for compliance with that policy, and to try to mitigate the employer's risks against having proceedings issued against them for a penalty.
So is it right to say, Mel, that there's no, though, one-size-fits-all approach to when you should necessarily go to the Ombudsman? It might depend upon the nature of your business and whether you have ongoing disclosure obligations or whether you don't, whether there's unions involved and how much they know about it. And I think strategically, there can be instances where it's best for an employer to try and tie the issue up and manage it and rectify the payments and then go to the Ombudsman with a closed result. But alternatively, there will certainly be cases, and I think you alluded to those with the supermarkets, where they do have ongoing disclosure obligations and they have to do it at an early stage and work with the Ombudsman collectively on getting the right result.
Absolutely, Mark, 100%. Every situation we have, every example that we have with clients has to be considered with all of those factors. And there will be quite a few where rectification is the best way and then disclosing to the Ombudsman. And we do need to consider all those factors. And quite commonly, as you know, we'll often work out, 2 or 3 various strategies for clients at the commencement of the process, depending upon how different stakeholders or different issues play out as we progress. And the other interesting thing to note is the Ombudsman is quite inundated. So, anecdotally, what we're hearing is that, going with some level of certainty as to what your issue is and the extent of that, and to a degree, I suggest even remediating that, might actually be received more favourably if it's a situation where that's appropriate, rather than just marching up and saying we've got a problem and not being able to provide any real context to what that problem is, the size of that problem, and what its impact is.
Terrific. Mel, I thought we might finish with just going through a couple of case studies without naming names, but as to how these underpayments issues can arise. And perhaps firstly, could you walk us through the scenario with regard to, in an annualised salary example, how that, maybe if you could explain what an annualised salary is, and then how that can lead to an underpayments issue.
Yeah, sure thing, Mark. I think this is something that employers have grappled with. It's one of those complexities that employers have grappled with for a long time. So we do see and have seen an increasing amount of issues arising with these sorts of annualized salary issues. So there's sort of 2 ways that this issue arises. So we've got the strict annualized salary or annualized wage provisions of awards. So that's where, for example, under the Banking, Finance and Insurance Award or the Clerks Award, an employee can be paid an annual salary in lieu of or in compensation for all award entitlements. So, I'm paying you $70,000 and that's all an inclusive rate. I'm not going to be paying you overtime penalty rates and so forth because that's all compensated for in your annual salary. That's sort of complying then with the relevant underpinning award obligations. The second way that we see it arise is what's known as a common law set-off clause, and that might be a situation where either an award does or doesn't provide for annualised salaries, but similarly to the annualised salary or wage provisions of an award, an employee is paid an annual salary in compensation for all award entitlements. And the idea is that they're paid sufficiently above the award minimum so as to compensate for all, overtime penalty rates and so forth that would otherwise be applicable. And provided the contracts are drafted appropriately and the employees are paid an adequate amount to compensate for those award entitlements, those arrangements are quite lawful. But what we're seeing is with these annualised salaries is quite often they're a set and forget. So what happens is someone is paid an amount, and the business thinks, okay, that's fine. I've paid Melinda $65,000. The award minimums are, 57, and that's going to be fine. But what it doesn't take into account is that the need to review those annualized salaries. So what we've seen, for example, is clients setting a salary which is actually not significantly higher than the award minimum, and then the employees work hours which attract shift loadings or penalty rates under the awards. And so what then happens is that the employees actually, if you're looking at the award entitlements, would have taken home more than what their actual annualized salary is. So if you do a comparison, for example, you're paying someone $57,000, but under the award, they should have actually taken home $61,000 based on their working patterns, shift arrangements, and so forth. And what happens there is that that we've seen that arise in many situations, and then year on year, when no one has reviewed the annualized salary arrangements, suddenly you can have quite significant underpayment claims or underpayments arising because those salaries aren't enough to compensate employees for what they would otherwise earn under the awards.
And what about industrial instruments, Mel? I mean, how hard can it really be to get them wrong? Surely they just set out what an employer needs to pay an employee from time to time for doing particular things, or isn't it that straightforward?
Well, Mark, you would like to think it is that straightforward, and I think sometimes it is, but sometimes it's not. One of the things that we're seeing, interestingly, increasingly, is payroll systems not being encoded correctly. So, for example, an enterprise agreement is negotiated by an IR team or employee relations manager or whoever it might be, and then there's changes to the relevant agreement. But the payroll system is not actually updated to reflect those new entitlements. So whether it's still coding things according to the former entitlement or things that are not coded correctly. So, for example, we had, there's a number of examples I could turn to, but one which sort of sticks in my mind is that an enterprise agreement was renegotiated, and the maximum breaks between shifts, so in a shift scenario, was 10 hours, so everyone gets a 10-hour rest break. And if the employees restart before their 10-hour break, they're paid at overtime rates for the rostered shift, which is pretty standard sort of clause. However, there was an exception to this where by mutual agreement, an employee could agree to return to work after 8 hours and forgo those penalty rates, so just be paid at ordinary rates. And in this particular scenario, what we saw was that the payroll system in question had coded the entitlement at an 8-hour rest break rather than the 10, meaning that the employees weren't getting their 10-hour rest period, and the penalty rates weren't actually being triggered. And as a result, when that is extrapolated across thousands of employees across a workforce, that small coding error can actually be very significant.
That simple award and agreement system coming back to roost again.
That it is, Mark, that it is.
Okay. Thanks very much, Mel, for taking us through some of the issues that arise with regards to underpayments. While there's a lot going on in the employment and industrial relations space at the moment, particularly with COVID, these underpayments issues are still bubbling away. And in my experience, they're going to continue to be a very, very significant issue for employers for many, many years to come, and perhaps until the award and industrial relations system is simplified somewhat. I want to thank everybody for listening to today's episode. Underpayments are certainly a very hot topic, and we'll no doubt see a lot more happening in this space. If you have any questions, please contact a member of our Employment and Workplace Relations team, and you'll find our details on our website, hallandwilcox.com.au, or you can connect with us on LinkedIn. If you've enjoyed today's episode, please rate, review, and follow our podcast wherever you listen to your podcasts. You can subscribe on our website to be notified of new episodes. Thanks very much.